ఏందండి అర్థం కాదు. బోర్డ్ యాక్చువల్లీ పీడిఎఫ్ కూడా కావాలి, పీడిఎఫ్ నేను పంపిస్తాను. పంపిస్తాను. Yeah. So let us start with the polities discussion. Yeah. I've talked to you about geography, I've talked to you about environment. We are able to bring up some elimination techniques in both geography and environment. But when it comes to polity, majority of the people know that there's no what you call elimination technique, right? Interesting, is not, yeah. There's no elimination technique as such when it comes to polity. Yeah. So, but I'll try to guess a pattern. I've actually come up with a pattern that I've observed, which is not 100% sure again. At the end of the day, UPSC has its own methods. All we can do is guess, and all we can do is analyze. So that is what all of the PYQ analysis is all about, right? It's all about analysis, not coming up with the short plan. It's all about analysis. So let us analyze all of the polity PYQs. Okay. Firstly, we adopted parliamentary democracy based on British model. Yeah, British model. As regards legislation, the British Parliament is supreme or sovereign, but in India, the power of the Parliament is to legislate is limited. As I told you, there is common sense that you actually get while reading. This is that kind of common sense where obviously we do not have parliamentary sovereignty. What do we have? Instead of parliamentary sovereignty, what do we have? Constitutional supremacy. Constitutional supremacy or separation of powers. These are the two aspects that we have. So obviously first one is wrong. First one is right. In India, matters related to constitutionality of the amendment of an act or parliament are referred to the constitutional bench by the Supreme Court. Again true. Anything that is related to constitution, who is it referred to? The Supreme Court. How many judges are there in the constitutional bench? How many? How many judges are there? In a constitutional bench. For example, if bench is hearing a constitutional amendment or something related to constitution, how many members are there in that bench? 5. That's what I'm asking. And what is the maximum number of judges for a particular bench? It has had till now. There are many cases that have happened. Keshavananda Bharati happened, Minerva Mills happened. 9? One option is 9. 7. 19 and 7. 2 for 7. Many people underestimate themselves. Do not underestimate yourself. What you are studying, everyone is also studying. Right? Have confidence in what you're studying. As long as you have confidence, as long as you have trust, everything can happen. Okay? A legislation which confers on the executive or administrative authority and unguided and uncontrolled discretionary power in the matters of application of law violates which one of the following articles? It is Article 32. Yeah. Now, what are the exceptions of Article 32? When can Supreme Court actually deny Article 32? Article 32. Why? It is a fundamental right. Why would Supreme Court deny a fundamental right? What are the cases? Emergency under 350? I sure it's 352. Ingo sir. But under which Article 32 can be denied? Which article is that? Mike. I don't think the batteries are there. How many pillows is there? My batteries. No batteries. Battery. Mike. Yeah, it is actually Article 359. While you are saying it is Article 352, but it is under Article 359 which denies people moving to Supreme Court under Article 32. Okay. Exception is Article 20 and 21, which are brought in under 44th Constitutional Amendment. Yeah, under 44th Constitutional Amendment, it was said that whatever you can do, you can actually deny all of the rights, but except for 20 and 21. Right? So what is Article 28? Religious? Audible? Yeah. What is Article 28? Establishment of religious institutions. Religious institutions and giving actually religious instructions. It's not about only institutions, it's all about religious instructions in the institutions. All the religious instructions given in the educational institutions. Right? There are 4 types of educational institutions. One is wholly maintained by state, right? Wholly maintained by state, and then recognized by the state, then administered by the state, and minorities are 29 and 30. Government recognized by the government, administered by the government, and aided by the government. Now, in which of these the religious instructions can be given, and in which of these religious instructions cannot be given? Okay, not given. Recognized by the state or where? Here I have given 4. One is wholly maintained by the state. One is recognized by the state, administered by the state, and aided by the government. These are all the state terms that are given in the Constitution. That is why I am giving these terms. Administered? No? In all of these, the religious instructions can be given, and all of these, it will be voluntary in nature. If they want, they can actually say that, yeah, we can actually accept these religious instructions. Otherwise, you cannot force them on them. But only in wholly maintained, you cannot have any religious instructions. That is all about Article 28. Then you have Article 14 and Article 44. Article 14 is about equality. 44 is about UCC. In which states do we have UCC now? Goa and Uttarakhand. Yeah, I heard. Uttarakhand, Goa, and Jharkhand. No, not Jharkhand. Gujarat. It's Gujarat. Recently, Gujarat has passed a bill. But what you need to know is that only Uttarakhand and Gujarat have passed complete UCC. Whereas if you actually look at Goa, it has only defined a very small or defined a narrow UCC. It is only for marriage, marriage, inheritance, inheritance and family. These are the only aspects in which Goa has laws on. Other aspects it does not have any law. Okay. So that is all about this particular question. Yeah. A legislation which confers on the executive or administrative authority an unguided and uncontrolled discretionary power in the matter of application of law. Application of law. No? It's application of law. No? Are you sure? A legislation which confers on the executive or the administrative authority an unguided, uncontrolled discretionary power in the matter of application of law. So don't stress on that much. That we'll discuss a little later. Okay, don't worry. Right to privacy is protected under which of the articles of the Constitution of India? Obviously, there's nothing much to think here. Yeah? There are some questions where there's no need to think at all. UPSC will give these kind of questions only in polity. It will not give in geography, it will not give in environment. It will only give these kind of questions in polity because polity is very big. So it doesn't want to complicate that much. So whenever it comes to fundamental rights or DPSPs, it will give you blind questions where you just have to take. Just don't be overconfident. Why not? Always a problem with this mic. I think the battery is not there. Battery. Yeah, I'll Mali Bodhi because the battery is not there. Okay, yeah. I'll try to switch it off. Unnecessary. Huh? Yeah. It's okay. Not an issue at all. Yeah, right to privacy is under Article 21. Then you have Article 29. What is 29? Protection of and linguistic minorities. This is for linguistic and cultural minorities. Religious. For both of these, it's there. It is for both. What do you call? Not only the minorities, it's also for the majorities. Article 30 is only for minorities, whereas Article 29 is for both minorities and majorities. Okay. Then you have Article 21 is about right to liberty, right? And Article 19 is about right to freedom of speech. What are the parts of freedom of speech? A to F. Yeah. What are they?
Freedom of thought and expression, freedom to assemble peacefully without arms.
Thought and expression. Assemble peacefully without arms. Right to movement. Profession. Associations. Decide. Right, all of these are there. Right to property has been removed. Yeah, these are all part of Article 19. Again, as you can see here, which one is what is the position of right to property in India? Right to property is under which article currently now? Right to movement, yeah. Right to movement is under Article 19 again. Yeah, we have restrictions. What is the restrictions? What do we need? There are two. One is the what do you call inner line permit, ILP, and the other one is for Indians, one is for foreigners. Okay, read it once. I don't remember. I remember that there's inner line permit, and the other one that is only for Andaman Nicobar and some states. Okay, just read it once because that is also important. Yeah, right to property is under fundamental right. Are you sure?
No, right to property. Sorry, it's a legal right.
It's legal right under Article 300A. It was brought in under which amendment? 44th Constitutional Amendment is which under 300A was brought in, and whenever it comes to these protections are not present for all the evacuee properties and enemy properties. What are evacuee properties? Evacuee properties. Evacuate is something when the partition happened. Some people evacuated from here to Pakistan. So all of the properties that were left behind are called evacuee properties, and those do not have any rights under Article 300A. Also, the enemy properties under Enemy Properties Act, they do not have any protection under Article 300A. Just remember that this is a legal right available to any person. Again, you have this question. The Supreme Court of India has held in some judgments that it is avoiding extreme. Foreigners also, yeah. Foreigners also can take. Yes, at the end of the day, it is investment. No, they can invest. Supreme Court of India has held in some judgments that the reservation policies made under Article 16(4) of the Constitution of India would be limited by Article 335. Article 335 is nothing but about reservation in appointments of SC and ST. Yeah? So that is about Article 335. It says that Article 335 of the Constitution of India defines the term efficiency of administration. But there's this particular elimination technique which says that whenever UPSC says that Constitution defines, it is usually wrong. But don't keep that in mind. There are many instances where UPSC has said that I'll prove you wrong. Okay, but generally it says that Constitution of India defines means it is usually wrong. And there's this another technique or another pattern which I actually noticed. If there is a question in polity, right? A question in polity, if one statement is wrong, the other statement is right. I'll show you the instances where one statement is wrong and all of the other statements are right. Okay, this is a pattern that I noticed, and that is not absolute again. This is a pattern only. Okay, here the answer is C. Under which one of the following articles of the Constitution of India has the Supreme Court placed the right to privacy? Again, 21. Final question? Oh yeah, sorry. According to the Constitution of India, the central government has a duty to protect states from internal disturbance. Which article is this? 355. What you need to remember is that the term internal disturbance was only removed from Article 352, not in 355. So internal disturbance is still there. So this is right. The Constitution of India exempts the state from providing legal counsel. Here you see, this is a positive statement. Yeah, this is a positive statement. What is it saying? It is saying government has to protect the states from internal disturbances. It is a positive statement. Here you can see the Constitution of India exempts the states from providing legal counsel to person held for preventive detention. Negative statement. According to the Prevention of Terrorism Act 2002, confession of the accused before the police cannot be used as an evidence. Negative statement. Right? Whenever UPSC gives negative statements, they are usually wrong, and this works usually in polity only. Okay, this will not work in other subjects. So that is why elimination techniques have to be applied in such a manner for each and every subject differently. Geography, there are some elimination techniques. For environment, there are some elimination techniques, and for polity, there are some elimination techniques, and all of them are not working for each and every subject. So answer is only one. Separation of judiciary from the executive. Which article is it? Article 50. Article 50 says that there needs to be a separation of judiciary from the executive in the public service of the state. Then valuing and preserving of rich heritage of composite culture. Which amendment? I mean, which fundamental duty? What are the fundamental duties? Can you list? 51A to 51K is abide by the Constitution and national anthem, and also national song is there. National song is there. Song is not there. Only national anthem is there. National anthem, national flag, and Constitution of India. Yeah, B's. What about C? Sovereignty of country and people. What about D? Defend our state. That you remember. Okay. Okay. E. It's okay. Try to remember all of these because they're asking questions clearly from you. Fundamental duties, fundamental rights, DPSPs are very important. In is that in fundamental duties? No, I don't think so. Fraternity is there. That is in, I guess, E. Derogatory, renounce derogatory of women and have fraternity amongst all of the members. And there are 3 more aspects in E only. Then F is about composite culture. Then G is about saving the environment. I is about protecting the public property. J is about what is J about? J is about scientific temper. H is about scientific temper. And K is about education of children and guardian. Right? Remember all of these. There's still how many days left? 24 days left. Try to revise all of the priority topics. What are the priority topics in polity? Fundamental rights, fundamental duties, TPSPs, parliament, state legislature, governor, president, vice president, judiciary. These are very, very important. Okay, and schedule 5 also. Schedule 5, schedule 6, and panchayat raj and municipalities. All. But you need to study in a chronology. Okay, you need to study in a chronology. There's no need for you to study one above and one below. You have to study in a chronology, and that chronology is based on importance only. You have to study constitutional and non-constitutional bodies. But that doesn't mean that you have to put a lot of energy on constitutional and non-constitutional bodies. You just have to know that which is constitutional and which is non-constitutional and who is the head. That is all you have to know. There's no need for you to know everything. For some aspects, you have to know everything. For example, fundamental rights and DPSPs. You have to know everything about them. Which amendment came at what time, and what are the particular tenets or what are the particular clauses in that particular article. You have to know all of that in these. When it comes to president, vice president, governor, you have to know about these. Okay. And prohibition of employment of children below the age of 14 years. Which article is this? 21A? No. 21A is about education. 24. Article 24 is where it is saying. What are the exceptions of Article 24? Yeah, they can work in non-hazardous places like family enterprises or entertainment industry, because we've seen many kids acting in the movies. So obviously they can work there. Yeah? So what are the exceptions? One is family enterprise, meaning that if it is any family business, and also entertainment industry. These are the 2 exceptions of Article 24. So all 3 is the answer here. Judiciary. With reference to India, consider the following statements. Judicial custody means an accused is in the custody of the concerned magistrate, and such accused is locked up in police station, not in jail. It's talking about police station. Police station means what? Police custody. Jail means judicial custody. PNP, J&J. Obviously, this one is wrong. During the judicial custody, the police officer in charge of the case is not allowed to interrogate the suspect without the approval of the court. Yes. Very legal. This is also something that you need to note. Whenever it is very legal, if the statement is very legal, then it's usually right. Okay. If the statement is legal. No. The statement is legal. Look at the terms. For polity, key terms are very important, and the key terms can be only noticed in legality. So answer is B only 2. With reference to the Indian judiciary, consider the following statements. Any retired judge of the Supreme Court of India can be called back to sit and act as Supreme Court judge by the Chief Justice of India with prior permission of President of India. True. Which article is it? 120? Sir? It is Article 128. Article 128 talks about retired judges, right? Reappointment of retired judges. Whereas Article 127 is talking about ad hoc judges. In both the cases, there is requirement of prior recommendation of president. Until unless prior recommendation of president is not there or prior permission of the president is not there, the CGI cannot appoint. Okay. A high court in India has the power to review its own judgment as the Supreme Court does. Yes, again true. Very generic statement. Yeah, both 1 and 2 is the answer. You can see here, there's no read of elimination techniques at all because all the statements are very plain. When a prisoner makes out a sufficient case, parole cannot be denied to such a prisoner because it becomes a matter of right. What is parole? What is parole? There are 3 terms. One is parole, one is bail, and one is furlough. Parole, bail, and furlough. Yeah. What is parole? Parole is something where the prisoner is actually let out for a temporary period. Right? A temporary period, and this letting out of that person temporarily is based on need. Let's say that person is in prison and his daughter's wedding is there. He'll go and ask the jail commissioner and ask him that please let me go. My daughter's wedding is there and I have to attend it because I'm the father. So if that person allows him to go out, that is called parole. And that is not a right. If they want, they can deny. Because why? That person has done some crime and let go of his rights. There's no humanitarian grounds for parole. Okay, there are no humanitarian grounds for parole. It is only based on need. That person, if the actually jail of the jailer or someone who is correspondent of letting the people go is accepting that particular demand, then only he'll let go. Otherwise, there's no right. Even though if they make a sufficient case, if they feel that it is wrong, they'll not let go. That is called parole. Bail is something where they are on trial, right? Those people are on trial and they want to be let out from the trial for a certain period of time. That is called bail. Bail is a right. Parole is not a right. Furlough again, furlough means it is also a temporary let go of people, right? Letting go of the prisoners temporarily, but this is not based on need. This is based on reward. If that person has been good in the prison for a longer time, the jailer or the correspondent will look at that person and say that you have been good and your behavior has been good, so we'll let you go. That's called furlough. Again, this is also not a right. Which is right? Only bail is right. State governments have their own prison release on parole rules. Why? Prison is a state subject. 1 is wrong, 2 is right. The pursuant to the report of H. N. Sanyal Committee, the Contempt of Courts Act 1971 was passed. Not sure. I don't know about this. Yeah. The Constitution of India empowers the Supreme Court and High Courts to punish for contempt of themselves. True. The Constitution of India defines civil and criminal contempt. This I know that it's not there. It is not defined at all. So 3 is wrong. Let us remove 3. C and D is wrong. So we know that 1 and 2 are right. From the options now we know that 1 and 2 are right. Let us see 4. In India, Parliament is vested with the powers to make laws of contempt of court. What is it saying? Act. Who makes acts? Did I need to know that H. N. Sanyal Committee made that particular act? I mean, recommended that act? No. I just had to read this. Key terms. Answer is wonderful. For this, you need awareness. You need to be very aware of what is going on in the exam. Government law officers and legal firms are recognized as advocates, but corporate lawyers and patent attorneys are excluded from recognition as advocates. Obviously not. Any lawyer is an advocate, right? Negative statement. Bar councils have the power to lay down the rules relating to legal, educational, and recognition of law colleges. Remember, I told you that if one statement is wrong, the other statement would be right. Yeah? Are you seeing this pattern? Here also, if you see, how many options are right? 3. Which one did I remove? 1. I just removed one option here. Here also, how many did I remove? 1. I'll show you so many more questions where only one option is removed and all the other options are right. Under the Indian Constitution, concentration of wealth violates what? Article 38. DPSPs only. Which article? It's Article 39. Right? Article 39A says that equality and they have equal opportunity, have same livelihood. Article B says that, what does B say? C is concentration of wealth. D is equal pay for equal work. E is no matter children, workers, men and women, their strength and health cannot be abused. S says that children should be given health and opportunity to have a good growth. Now, what is B? That is 39A. 39A is free legal aid. Talking about 39B. One is equality among men and women for livelihood. One is concentration of wealth. One is equal pay for equal work. Then is children, workers, men, women have strength and that cannot be abused. F is children and health. What is B? Distribution of wealth. Yeah, states taking over of distribution of wealth. Yeah, that is all about Article 39. Remember all of the clauses. This is what I was saying. All the clauses are important because UPSC is asking. What? Many people would be able to eliminate these two, but they'll be stuck between these two because concentration of wealth is actually against equality. So many people would take this and come back, but then they'll come and check Article 39 will be here, Article 39C. Okay, so that is why the clauses are very important. With reference to the anti-defection law in India, consider the following statements. The law specifies that a nominated legislator cannot join any political party within 6 months. Within 6 months, that person can actually join. Why? Why not after 6 months? Why did they put within 6 months as a clause? Why not after 6 months? It's too hot today, no? The reason they are given within 6 months is because within 6 months they have to make a decision. Right? They are giving a timeline to make a decision for the nominated person to join a political party. If they give more time, what will they do? They'll jump from one political party to another political party. What will that happen? What will that do? What will that do? There's a lot of instability. It creates instability. In order to tackle that instability, they came up with this particular clause. The law does not provide any time frame within which the presiding officer has to decide a defection case. True. Yeah? Again, if you see, one statement is wrong, one statement is right. Which of the following statements is correct as per the Constitution of India? Interstate trade, interstate migration, interstate quarantine. All of those are interstate. What is interstate? Something, if something is interstate, which list will it belong to? If something is interstate, which list will it belong to? Interstate. If something is interstate, which list will it belong to? Concurrent list? Are you sure? Union list. That is the reason they cancelled this one. Article 19B. I mean, sorry, Schedule 9B. What is Schedule 9B? Cooperatives. They removed the clause of state cooperatives. They added the clause of, sorry, they let the multi-state cooperatives stay. Why? Because interstate is always part of concurrent list. I mean, sorry, union list. So let us look at all the options where it is given state list. Interstate trade is given state list. Interstate migration, it is given state list. Interstate quarantine. See, interstate quarantine is a union subject under the union list. Okay. The Constitution, 71st Amendment Act 1992 amends the 8th schedule of the Constitution to include which one of the following languages? It is Konkani, Manipuri, Nepali. What are the other amendments? 21st, 71st, 92nd, and 96th. 96 is Odisha. Yeah. 21st they added Sindhi. 71st they added Cayman, Konkani, Manipuri, and Nepali. And 92nd they added Bodo, Santali, and Dogri, Maithili. And 96 they added, and they changed the name from Odisha to Odia. Yeah, that is what they changed from 21st, 71st, 92nd, and 96th. So the answer is 1, 2, 3. Again, what do you see here? No, it is under Article 3, I guess. Article 3 is not a constitutional amendment. What are the things that are not under constitutional amendment? Meaning that if anything is made to the Constitution, which is not under Article 368, any amendment that is not in the Article 368 are 1, Article 2, Article 3, Article 4, then what else? Article 2, Article 3, Article 4. Next. Delimitation. And citizenship. I don't think so. Yeah. Citizenship is a law. I don't think that is seen. Yeah, fine. Citizenship is there. Yes. Citizenship. Next. Think. Fifth and sixth schedule. Quorum of Parliament. And English as a language. Addition of puissant judges. Right? All these are under what? Amendments which are not considered as Article 368, or the constitutional amendments that are not under Article 368. What are they? Article 2, 3, 4, delimitation, citizenship, Article 5, Schedule 5, Schedule 6, quorum of Parliament, English language, and addition of puissant judges. All of these are not part of Article 368. So yeah. You guys right? Yeah, 96th. Change in name. Yeah, change in name requires. But for this, What did you say? Is it for states?
Yes, sir.
For states, it does not require constitutional amendment under Article 368, but it requires constitutional amendment. See, there are amendments which are under Article 368, and there are constitutional amendments. Both of them are amending constitution, but there's a division between those amended under Article 368 and those amended not under 368. These are all not under 368, but are constitutional amendments. Okay, everything is a constitutional amendment. If you are changing something in the constitution, it is a constitutional amendment, but it does not come under Article 368. That's it. Okay. Yeah. Should I remove this? It has written. I think it's writing. Okay. Yeah. Which of the following statements are correct? Powers of the municipalities given in Part 9A. Yes, municipalities are under Part 9A, and panchayats are under Schedule 9 and Part 9. Emergency provisions under 18. True. Provisions related to amendment of the constitution under Part 20. All of the three are right. Yeah. Now municipalities, there is metropolitan committees and district planning committees, and also ward committees. Right? These are the three type of committees that are present under 74th constitutional amendment. Now, for metropolitan committees, MPC, how much is the amount of members elected? What is the percent of, or what is the fraction of members elected for MPC from the state assemblies?
All the MLAs are part of it.
All the MLAs, but how much? There's a fraction. 1 by 12. Are you sure? That is nominated by governor.
1 by 3.
Local MLAs who are related to that particular municipal area,
Yeah.
they are part.
Yes, they are part. But there is a fraction. Only that fraction of members should be elected into that MPC. For MPC, it is two-third members of the state assembly. Whereas for DPC, for district planning committee, it is 4/5 members of assembly. And when it comes to ward committees, a ward committee can be only formed if there are 3 lakh plus members. Okay, 3 lakh plus members only, ward committees can be formed. And for district planning committees, you need 4/5 members of state elected members from assemblies. For MPC, it is 2/3 members. All right. So 1, 2, 3 are right. D is the answer. If any question arises to whether a member of the House of the People has become a subject to the disqualification under the 10th schedule, the President's decision in accordance with the opinion of the Council of Ministers shall be final. Is it? It's saying 10th schedule. For 10th schedule, it is Speaker. Then where does President do? Under which article? President disqualifies MPs under which article? Is Article 1 or 2? Yeah. And under what Article 1 or 3, it says that President is the one who disqualifies the MP, and on the recommendation of Election Commission of India. Right? There's no mention of the word political party. The word political party is actually mentioned in 10th schedule. UPSC can ask these kind of words. What are the words that are present in Constitution? Is cabinet present? Cabinet, MCC, federal, and collegium. Then 0 hour, question hour. How many of these words are present in the Constitution? Cabinet, Model Code of Conduct, Federal, Collegium. So there are 1, 2, 3, 4, 5. Out of 6, how many are there?
Cabinet is present, sir.
Cabinet later added. Question number also 0 is later added.
Ashok?
Yes.
Only cabinet is there. MCC, Federal, Collegium, 0 hour, question hour are not there. Yeah, cabinet is mentioned in the Constitution in national emergency. I think it's in the national emergency, Article 352. Yeah? Cabinet is actually mentioned in the Constitution. The term federal is not mentioned. MCC is not mentioned. Collegium is not mentioned. Similarly, but political parties mentioned. But what you need to understand is there's no need for you to remember all of these. Obviously, UPSC is not expecting you to remember. Okay. How can you remember whether the particular word is there or not? Constitution is a very big book. It has, how many articles does it have? Nearly 460, 470 articles. 470 articles are there. Many schedules are there. How can you remember whether the particular word is there or not? UPSC is not asking you to remember words at all. Okay. It is trying to give you hints like this. As I told you again, if one statement is wrong, the Constitution of India classifies the ministers into 4 ranks: Cabinet Minister, Minister of State, Independent Charge, and Minister of State and Deputy Minister. What is it saying? Saying Constitution of India classifies. Actually, it's wrong. If you actually go by the trick, would the second statement be right? Yeah. Under which constitutional amendment is it? 91st constitutional amendment. It says that 15% should be there and the minimum should be 12 members. 12 members is the minimum and the maximum is 15%. And what are the other things that have been brought in 91st constitutional amendment? First is this 15% should not exceed. What else? They removed the 1/3 clause and added the 2/3 clause, or left the 2/3 clause. Okay, so you need to remember this because some people have shifted from ARK to BJP. You might get a question on this. Might. This is still not accurate. Might get a question on this. Okay, 2/3, and it also says that any person who is disqualified under defection cannot be a minister. Any person who has been disqualified under anti-defection cannot be a minister. These are all the clauses that have been brought through 91st Constitutional Amendment. So answer is only 2. Yeah. With reference to the government of the following, union government, consider the following statements. It is a very hard question. Yeah. Sometimes UPSC will give these kind of questions. There's no way you will be able to know. But you have to use some kind of elimination techniques. N. Gopalswamy Iyengar committee suggested that a minister and secretary be designated solely for pursuing the subject of administrative reforms and promoting it. In 1970, the Department of Personnel was constituted on the recommendation of ARK 1966, and this was placed under minister's charge. There's no way you would know this. There's no way you would know this because it is a very factual statement. It's talking about ARK and it's talking about N. Gopalswamy Iyengar committee. Both of these committees you have to know, should have studied. Only if you have studied, you would have been answered. You would have been able to answer this question. But if you actually go on this elimination technique, first one is wrong. Second one is right. Yeah. So B only 2 is the answer. Prorogation. With reference to the Parliament of India, oh yeah, yeah. 50. Acha, ikkada. I discussed this now. More above. Acha, this one. Okay, sorry. Consider the following subjects under Constitution of India. List 1, Union's list, is 7th schedule. Extent of executive power of a state and conditions of the governors of office. For which of the constitutional amendment does require half of the ratification of state? Is saying in which amendments does ratification of state required? One is Union list, right? Second is extent of executive power of the state. But for conditions of governor's office, it is not there. What are the other aspects in which ratification of state is required? Amendments? What amendments? Representation of Council of States.
Whatever the amendment that affect the states that require
Council of States, and those are all present in 7th schedule only. It's talking about 7th schedule. Everything that is related to state is present in 7th schedule. So 7th schedule is one, right? And representation of councils act, Council of States is one. And then you have extent of power of a state, meaning that division of powers it's talking about. What else? One more is there. What is it? Why? Any constitutional amendment like you're saying? Yeah. Division of powers is affecting states. Representation of Council of States is affecting states. What else? Election of president. Right? These are all the clauses or instances where ratification of the states is required. Election of president, division of powers, 7th schedule, and representation of Council of States. So answer is, we removed how many options? One option, and both the others are right. I think we'll discuss this. We'll discuss this one also, and this one also. Parliamentary procedure. Prorogation of a house by the President of India does not require the advice of Council of Ministers. Obviously, President is bound by the advice of Council of Ministers. So first one is wrong. Prorogation of house is generally done after the house is adjourned sine die, but there is no bar to the President of India to prorogate the house which is in session. That's also true. Yeah. Dissolution of Lok Sabha is done by the President of India, who, save in exceptional circumstances, does so on the advice of Council of Ministers. Again, true. Now, what happens to the bills when prorogation has happened? Do the bills lapse when prorogation is done? Adjournment is done by Speaker. Adjournment sine die is done by Speaker. Prorogation is done by President. Now, what happens when prorogation is done? Do the bills or notices, all of them lapse? Why not? It's not dissolution. It is only closing of the session. What happens when dissolution happens then? Which bills lapse when dissolution happens? Lok Sabha, yeah.
Depends on which house is dissolved.
Rajya Sabha will not dissolve. Rajya Sabha is a permanent house.
Whatever the bills comes from the Lok Sabha, which crosses the Lok Sabha, then it will.
Any bill that is passed by Lok Sabha, one, and passed by Lok Sabha and pending in Rajya Sabha will not lapse. Right? What about passed by Lok Sabha, passed by Rajya Sabha, and pending with President? Not lapse. Because anything that President touches will not lapse. Keep this in mind. Okay? Anything that Lok Sabha touches will lapse. If that particular bill is touched by President, it will not lapse. So yeah, answer is 2 and 3. Right? It is the governor of the state who recognizes and declares any community of the state as a scheduled tribe. No, it is not the governor, it is the President. President notifies the scheduled tribe based on the recommendations given by the governor. After the first instance, it is the Parliament who will again add or remove the scheduled tribes. Okay. At the first instance, it is President. First instance, it is President who is taking recommendation from the governor or the consultation from the governor. Then it is declaring a list. From the second time onwards, it is the parliament. All right. So yeah, a community declared as a scheduled tribe in a state need not be so in another state. Yes, because why? Why are scheduled tribes actually brought into a list? Because there are minority. In one state they might be a minority. In another state they might not be a minority. So that is why in one state it can be an ST community. In another state it cannot be. So 2 is right. 1 is wrong. How many did we remove? But there are some questions in which these kind of things will not work. But if you actually see, how many questions did we answer? Nearly 20. Out of 20, how many did it work? Almost all. So out of, let's say, if there are 100 questions, in 90 questions it will work. In 10 questions it might not. But you never know which question it will be. So try to depend on your knowledge more on and luck on luck a little less. Okay. That is also true. All B's. With reference to the schedule areas, within a state, the notification of an area as schedule area takes place through an order of the president. True. We discussed just now. Any area being declared as schedule area or the boundaries, everything is declared by president only. The largest administrative unit forming the schedule area is the district, whereas the lowest is the village. True. Lowest is village, highest is district. The chief minister of the concerned states are required to submit annual reports to the Union Home Ministry on this administration of scheduled areas. No, it's governor submitting to president. How many did we remove? Only 1. Yeah. With reference to the Constitution of India, if an area in a state is declared as a scheduled tribe or scheduled area in under 5th schedule, the state government loses its executive power in such an area and local body assumes total administration. No. What are the parts of schedule area? I mean, 5th schedule. How many states are there? What are they? MP, Chhattisgarh, AP, Telangana, Orissa, Jharkhand. Arunachal Pradesh is not there. And not there. Not there. Maharashtra, Gujarat, Bihar is not there. Rajasthan. How many happened? 1, 2, 3, 4, 5, 6, 7, 8, 9. One more state. Himachal Pradesh. Yes. These are the 10 states that are present in Schedule 5. Yeah. Now, in Schedule 5, we have Tribal Advisory Council. How many members are there in Tribal Advisory Council? 20 members. Right. And is there anything else that is present in Tribal Advisory Council? Who is the main person who leads all the Schedule 5 areas? Governor or president? Governor. It is only the president declaring the schedule areas. President declares the schedule areas, but all the governance happens through governor only. Yeah. Then you have Schedule 6 areas. Schedule 6 areas include? What are the 4 states? Assam, Meghalaya, Mizoram, and Tripura. What is the council that is there in Schedule 5, Schedule 6? Autonomous District Council, ADC. How many members are there? 30. And out of the 30, 26 are directly elected and 4 are nominated by the governor. Now, what are the powers of Autonomous District Council? What are the powers of ADC? Can make laws? Can make laws. Laws on many aspects, including on forests. Forests except reserved forest. Right? They can make laws on forest except for reserved forest. right? They also have authority to control finances. They also have judicial powers. What are the judicial powers that autonomous district council has? Village panchayats, village courts. Village courts is the judicial power that the autonomous district councils have. Okay, that is all about Schedule 5 and Schedule 6. Read a little more about Schedule 5 and Schedule 6 because it is very important. There are small areas which UPSC might pick because it is obviously exhausted. It has given questions on many topics. It has taken one topic and it has tried to reverse it. It has done a lot of things. But now, as it is exhausting, it will try to find even more deeper topics which students are not studying. Okay? That is why I study Schedule 5 and Schedule 6 a little deeper. Also, 74th Amendment and 73rd Amendment, because you haven't seen questions on those amendments a little late, right? This act is for Schedule 5 areas. It's not for Schedule 6. PESA is not for Schedule 6 areas. It was only for Schedule 5 areas. Okay, and it is statutory in nature. It's an act. Okay. The union government can take over the total administration of such areas under certain circumstances on the recommendation of the governor. There's no way they can take total control because obviously there's the reason they gave Schedule 5 and Schedule 6 areas. Why? To give them protection, to give them their own autonomy. Even if you take full total administration in such areas, what will happen? You're taking away their rights. Obviously, both 1 and 2 are wrong. Panchayats are at the intermediate level. Yeah. Panchayats at the intermediate level exist in all states. Is it? They're not in all states, and only in states where the population is less than 20 lakhs, there is no intermediate stage. Intermediate stage is not there in locations where there's less than 20 lakhs population. Right? So that is why first one is wrong. To be eligible to be a member of panchayat at the intermediate level, a person should attain 30 years. 21 years. The chief minister of a state constitutes a commission to review the financial position of a panchayat at intermediate level and make recommendations regarding the distribution and net proceeds of taxes, duties leviable by the state between state. He gave you a big paragraph, but he gave the hint in the start on. It's not the chief minister. Who assigns the finance commission? Governor. Yeah, constitutes. Who constitutes the finance commission? Governor. Governor constitutes the finance commission. So 3 is also wrong. All the 3 statements are wrong. Right? Nature of the bill. With reference to finance bill and money bill in India, in the Indian Parliament, consider the following statements. When the Lok Sabha transmits finance bill to Rajya Sabha, it can amend or reject bill. Yes. Why not? What are the three types of bill? Money bill, financial bill 1, and financial bill 2. Money bill is under which article? 110. Sorry, 110. Is under article 110. Financial bill 1 is under 117. 1. Sorry, 117. 171. 3 or 2? 1. 3 or 2. Anything is fine. Okay. Yeah. What are the clauses under each? Money bill, finance bill, and financial bill 2. Okay, cannot be rejected by Rajya Sabha. Is there joint sitting in money bill? Joint sitting is not there. Does it require president's recommendation? President's recommendation is required. Huh? And it's only about appropriation and taking of money and custody of money. Right? All of these are present in money bill. Then you have financial bill. It includes aspects of money bill and non-monetary also, other than financial bill. Does this require president's assent? Meaning that for introducing. It is required. Is there joint sitting? Can Rajya Sabha reject or amend? Rajya Sabha cannot reject or amend. Okay. But when it comes to financial bill 2, it includes non-monetary, nothing related to money bill at all. And it does not require president prior recommendation. And there is clause for joint sitting. And Rajya Sabha can amend, reject this particular bill. This is all about money bill, financial bill 1 and financial bill 2. All right. Other bill they consider under money bill. Why? Because Rajya Sabha cannot reject or there is no scope for joint sitting. That is why they consider it as money bill. So yeah, first statement is right. When the Lok Sabha transmits finance bill to Rajya Sabha, it can amend or reject the bill. When the Lok Sabha transmits money bill to the Rajya Sabha, it cannot amend or reject the bill. Again true. Yeah. In the case of disagreement between Lok Sabha and Rajya Sabha, when it comes to there is no joint sitting for money bill, but a joint sitting is necessary for financial bill. It is not necessary at all, right? It is not necessary. So 3 is wrong. How many statements did we remove? Only one statement. And many bill should not be introduced. Okay, here. Article 109 mentions special procedure in respect of money bills. Yes. It says that it can only be introduced in Lok Sabha and Rajya Sabha has less powers and it has to return back within 14 days. All of these are present under Article 109. A money bill shall not be introduced in Council of States. True. The Rajya Sabha can either approve the bill or suggest changes but cannot reject it. True. Amendments made to a money bill suggested by the Rajya Sabha had to be accepted by the Lok Sabha. No. So how many are correct? How many did we remove? Yeah, you're noticing a pattern, right? You also finished. Yeah. Consider the following organizations: National Commission for Backward Class, NHRC, National Law Commission, and also Consumer Disputes Redressal Commission. How many of the following are constitutional bodies? If you see here, what are the kind of questions that it is asking? It's only asking which is constitutional and which is not constitutional. So whenever you are studying this, there's no need for you to go in depth. That is what I was talking about when I was saying priority. There are some topics which you need to study in depth, like fundamental rights, president or vice president, because they are asking a little deeper questions. But for these kind of questions, it is asking surface level questions. So you just have to turn the pages and see which one is constitutional, which one is not constitutional, and which year did they come in, which came first, which came second. Those are all that you need to do. Okay. So yeah, it is only National Commission of Backward Classes which under 102nd Constitutional Amendment. What is 103rd? 103rd is EWS. 104th? Extension of reservation and cancellation of Anglo-Indians. Right? Again, only one is right. These two are not. Only one is the answer. For this, you need to study actually 15th Finance Commission. So even 16th Finance Commission came, so study a little on that. UPSC has asked 2 Finance Commission questions. Okay, Finance Commission is under which article? 280. Who appoints Finance Commission? Finance Commission who appoints? President. President after every 5 years. And what is the manner? Who prescribes the manner of selection or members or qualification of the members? Why not president? President appoints. Who decides the manner of election, selection and qualification of the members of the Finance Commission? Is what I'm asking. It is the parliament. Right? Parliament declares the law under which the qualifications and the manners of election of the members of the Finance Commission is selected. Right? So yeah. So now 15th Finance Commission, at that time, there's this mnemonic called IPAD FT. IPAD FT means income, population, area, demography, forest, and tax efforts. If you actually look at this particular mnemonic, then you could be able to eliminate 1, 2, 3. Only 3 is the answer. Now, 16th Finance Commission came and said that we are removing what? What did they remove? Tax efforts, and they replaced tax efforts with contribution of GST. I mean GDP. Contribution to GDP is a thing that they've added. Okay, and they let the 41% remain the same. 15th Finance Commission said that 41% plus 1%, and that 1% will go to the newly formed Union Territories, that is Jammu Kashmir and Ladakh, and the other 41% will be the devolution for the states. 16th Finance Commission said that there's no need for you guys to increase the devolution amount. Let it stay at 41% only. Rather, we'll remove this particular tax effort and we'll add contribution to GDP. Okay, so B is the answer. Northeastern Council. Northeastern Council was established by the Northeastern Council Act 1971, subsequent to the amendment of Northeastern Council Act in 2002. In the 1971, there were only 7 states. Right? In the 1971 Northeastern Council Act, there were only 7 states. After the 2002 amendment, there were 8 states. Which one was added? Sikkim. Sikkim was added in 2002. Now, who are the members of the council? It is all governor, chief minister, members nominated by the president, also home minister. Right? All 1, 2, 3, 4 are the answer. How many of the above were established as per the provisions of Constitution of India? Interstate Council only. Article 263. Who appoints Interstate Council? Parliament or President? Sure. President. It is, if it was the interstate water dispute, then Parliament. If it is between states, it is President. Okay. It was actually based on Sarkaria Commission's recommendation. Right? It was based on Sarkaria Commission's recommendation. When was Sarkaria Commission? Which year? 19? That was Punchi. 1986, Punchi. 1969, Rajmanar. 2010. 2010, yeah. 2007, Punchi. Sarkaria, I guess it is in 1990. 1990, yeah. So yeah, Zonal Council. It is under which act? Act. Zonal Council. What if you get a question on the board? They give you a box saying Interstate Council, Article 263, Zonal Council. They'll give you some act here. What will you do then? There's a specific act. It's called State Reorganization Act. State Reorganization Act 1956. Under which how many councils are there? 5 councils. What are they? North, East, Central, West, South. These are all the councils that are present in Zonal Council. Who is the chairperson of Zonal Council? Home Minister is the chairperson of the council. When it comes to National Security Council, it is PM. Okay, Prime Minister is the head of National Security Council. For Zonal Council, it is Home Minister. And there are 5 councils and it is under State Reorganization Act 1956. So answer is only 1. The powers of Lokpal applies to public servants of India, but not to the Indian public servants posted outside India. The chairperson of a member shall not be a member of parliament or a member of legislature or any state, and only Chief Justice, whether the incumbent retired, has to be its chairperson. The chairperson or a member shall not be a person of less than 45 years of age on the date of assuming office as a chairperson or a member, as the case may be. Lokpal cannot inquire into the allegations of corruption against a sitting Prime Minister of India. How many of them are right? What is Lokpal? Under which act is it? Lokpal and Lokayukta Act 2013. Lokpal and Lokayukta Act 2013. How many members should be there in Lokpal? %50 should be judicial, and 50% should be members from SC, ST, OBC, and minorities, women. Right? All of these should be 50%. Then, who are the members that are under Lokpal? Under the guise of Lokpal. Right? One is ministers, then MPs, then Group A, B, C, D officers, and All India Service. Then you have NGOs that are financed by government, and also public sector companies. Central government, public sector companies are there in there. What about PM? What is the committee that is for the chairperson of Lokpal? Who are the members present in the chairperson? The committee that selects the chairperson of Lokpal. PM, LOPLS, CJI, Speaker of LS, eminent jurist appointed by President. Right? These are all the members present in the committee that is appointing Lokpal chairperson. Now, what about PM? PM is actually in the committee. So is PM still there? Yes, PM is there, but only for some aspects. The corruption or the allegations of corruption cannot be checked in for PM in cases of international relations, internal and external security, and external security, then atomic energy, then you have defense and space. These are all the aspects in which the Prime Minister cannot be checked for allegations of corruption. What are they? International relations, internal security, external security. What else? Defense, space, atomic energy. All these are the exceptions for Prime Minister. That's all you need to know when it comes to Lokpal. And for Lokayukta, every state has its own rules. So there's no particular rule saying that this is the common framework for Lokayuktas. Every particular state has its own rules. But for Lokpal, it is this. Right? 50% judicial, 50% SC, ST, OBC, and women. Ministers, MPs, Group A, B, C, D officers, All India Service, NGOs, and public sector companies. And then Lokpal's committee has PM, Leader of Opposition, CJI, Speaker, and eminent jurist. And lastly, what are the exceptions? International relations, internal security, atomic energy, defense, and space. Right? So here the answer is you're removing two statements, not one statement. Again, if you see, what did UPSC do? It is breaking the pattern. So answer is 2 and 3. But if you actually also notice, if it is not 1, 2, 3, 4, UPSC will still give hints like this. It's saying that it is not 1, it is only 1 or 2 options that is correct. It's not 3. So you are trying to apply a trick. Look at the options and then apply the trick. Okay. Amendments. A bill amending the constitution requires a prior recommendation of the president. No. obviously it does not require prior recommendation of president. When a constitutional amendment bill is presented to the President of India, it is obligatory for the President of India to give his assent. True. A constitutional amendment bill must be passed by both Lok Sabha and Rajya Sabha by special majority, and there is no provision of joint sitting. True. There is no joint sitting for constitutional amendment. Only for ordinary bills and financial bills. Those are the only bills for which joint sitting is there. So 3 is wrong, 2 is wrong, 1 is right. No provision for joint sitting. Sorry, my bad. Again, we removed just one statement here. In India, which of the following constitutional amendments was widely believed to be enacted to overcome the judicial interpretations of fundamental right? It was the first amendment. They brought in which schedule? 9th schedule. 9th schedule was brought in first constitutional amendment. Which law? Which case? Which case was it? Shankari Prasad. It was in 1951. Before Shankari Prasad case, there was Champakam Dorai Rajan case. If you actually know, there's a chronology. First Champakam Dorai Rajan, then Shankari Prasad. Why not 42nd? Overcome judicial interpretations. What was 9th schedule? What did 9th schedule do? Is there a clause in 42nd amendment that there's no judicial review for some aspects? But in first schedule, they created 9th schedule. First amendment, they created 9th schedule in which they said that certain acts will be put in 9th schedule in which there won't be any review for judicial. Judiciary cannot touch those particular amendments or acts is what 9th schedule said. That came in first constitutional amendment only. That is why this is more relevant to first constitutional amendment, right? Yeah.
In the 44th constitution, they have changed whatever the provisions in the 42.
True. True. They started and they changed actually 44th. But actually, if you see judicial interpretations, it's talking about judicial interpretations, not judicial review. Because of discrepancy, discrepancy only. But he actually gave one as the answer, right? UPSC does this every time. Despite having 1 year time, it will come up with 100 questions in which it will remove 3 or 4 questions. We cannot do anything. All we can do is try to guess, right? So yeah. As per the Constitution of India, as per Article 368 Constitution of India, the Parliament may amend any provisions of the Constitution by the way of addition, variation, and repeal. All are there. They can add, they can vary that particular amendment or repeal that particular amendment. Anything can be done, right? So answer is 1, 2, and 3. Parliament and House, right? Which of the following is the exclusive powers of the Lok Sabha? Ratification of emergency? No, it is both Rajya Sabha and Lok Sabha. Passing of no confidence motion? True. Impeachment of president? Again, Rajya Sabha and Lok Sabha. Now, what are the exclusive powers of Lok Sabha? Money bill. Joint sitting. It's not exclusive power, no. Rajya Sabha is also there. Not necessarily. That's not an exclusive power. That is an advantage. That is an advantage, but not the power. What else? Cancellation of national emergency. No confidence. Council of Ministers? Again, that is not a power. That is a system. and that is called parliamentary system. Collective responsibility is what the nature of parliamentary system. That is not a power. Demand for grants. All the motions, right? Adjournment motion, cut motion, policy motion. All of these are what? Lok Sabha's exclusive powers. Now, what is policy cut and token? Policy cut and token. Policy is by 1 rupee. And economy motion, I guess. Easy. Token is 100 rupees. And this is policy. Policy cut motion. What is the other motion? Economy motion, no? Or 3 motions there. Policy motion, token motion, and what is the other one? Economy one. Right? What do they do? Why 1 rupee and why 100 rupees? What does 1 rupee mean? What does 100 rupees mean? Why 1 rupee? Are they cutting it by 1 rupee or are they cutting it to 1 rupee? By 1 rupee?
Total cut motion was, then the government need to resign.
Okay. But are they cutting by 1 rupee or cutting to 1 rupee is what I'm asking. By. By. It is they are cutting to 1 rupee. Meaning that it is symbolically saying that there is no need for you to give money at all. Take this 1 rupee, I'm cutting it to 1 rupee and not cutting by 1 rupee. For token motion, they'll cut by 100 rupees. Saying that you need to make some changes. So for token motion, they are cutting by 100. For policy cut motion, they are cutting to 1 rupee. They're reducing the whole from 10,000 crores to 1 rupee. So they want to close that division. That is why it leads to no confidence. Okay. So remember this, because UPSC might trick you with this, by 1 rupee or to 1 rupee. It is a very small word. That one word can give you +2 marks or give you -0.66. Okay. So don't worry. Yeah. To ratify declaration? No. To pass? No confidence? Yes. To impeach presidents? No. B only 2 is the answer. Constitutional bodies. Many people would think that as there is numbers, we have to remove those. But if you remove like this, what will happen? -0.66 only. We don't know whether it has recommended grants for 48,000 crores from the year 22 to 23 to the year 25-26. Because obviously, whenever I read the budget document, I wouldn't look at the numbers. Because UPSC is not asking numbers. And UPSC is also expecting you to not remember numbers at all. It's asking you whether are you remember the important aspects. Right? If you remember the important aspects, you'll be able to answer this. What is the important aspect of 15th Finance Commission? It is 41% devolution. Here he has given the statement that said that 45% of the net proceeds of the union taxes are to be shared with the states. So which one should I remove? I should remove second statement. Yeah. I didn't have to know whether it was 45,000 crores. I didn't have to know whether it was 4,800 crores. I only had to know this one statement. That's it. Right? So answer is C. 134. Governor. The Constitution of India explicitly mentions that in certain spheres, the governor of a state acts in his own discretion. The President of India can, of his or her own, reserve a bill passed by a state legislature for his or her considerations without it being forwarded by the governor of the state. Meaning saying that President can do it suo motu. President cannot do it suo motu. Then why is there governor? Governor is an agent of president. So 2 is wrong. Obviously, if we go by the trick, which one is right? 1 is right. Okay, but let us understand one. What are the aspects in which there is constitutional discretionary for governor? Yeah, constitutional governance. I mean, governor has some discretionary powers according to the governor constitution. Okay, now what are the powers under the constitution which are discretionary for governor?
You can reserve the bill for president.
Under Article 200, governor can reserve the bill for consideration of the president. And then you have Article 356, where you are reserving or telling the president for president rule. Yeah, constitutional machinery under Article 365, right? And then you have Schedule 5 and Schedule 6, where governor is doing his own duty. And also there is Article 371A. Article 371A is about which state?
Yeah.
Nagaland. Then 371B is all about Manipur. 3C is Manipur. C is Manipur. 371C is Manipur. Then 371H. 371 is H is Arunachal Pradesh. What is 371B? Assam. 371B is Assam. So these are the constitutional discretions given to the governor. So when it comes to discretionary power, the governor has more discretion compared to president. President is bound by the advice of Council of Ministers, whereas the governor is not bound by the advice of Council of Ministers. Where is doing Article 200, Article 356, Schedule 5, Schedule 6, 371A, 371B, 371C, and 371H. These are all the places where governor is showing his discretion. So one is right, two is wrong. The governor of a state is not answerable to any court for the exercise and performance of the powers and duties of his or her office. No criminal proceeding shall be instituted or constituted against the governor during his or her term of office. Members of a state legislature are not liable to any proceedings in any court in respect of anything said within the house. What are they? What is it talking about?
Privileges.
Privilege. Now, presidents and governors' privileges under which article?
Order to MP's privileges.
That is why I am asking president and governor. (361) is the article under which governor and president have privileges. Under these articles, governor of the state is not answerable to any court, and there are no criminal and proceedings that can be taken place. But when it comes to civil proceedings, for governor and president, it is 2 months. Right? It is 2 months for governor and president. But for the members of the parliament, it is 40 days. Okay, 40 days before and after. And they can be charged criminally. And they are under articles 105 and 194. 105 for parliament and 194 for state legislature. Okay, and under article 194, members of state legislature are not liable to any proceedings in any court in respect of anything said within the house. So all three are right. Which of the following is the essential feature of that indicates the federal character? What are the features of federal nature? Right? What are the federal characteristics? Federal. Separation of powers. That is division of powers. You can add division of powers, but not separation of powers. Separation of powers is between the organs. So federal is not separation of powers. Okay, it is division of powers. So one is division of powers. Unitary feature, yeah. What else? Written constitution, rigid constitution, and supremacy of constitution. Right? Rigid constitution, written constitution, and supremacy of constitution. Then you have dual polity. Single polity is again unitary feature. Single citizenship, single constitution, all of them are unitary. Dual polity. What is dual polity? Yes, center and state is nothing but dual polity. What else? Division of powers, independent judiciary, written constitution, rigid constitution, supremacy of constitution, and dual polity. One more is there. Bicameralism is another feature of federalism. What about parliamentary system? What are the features of parliamentary system? Collective responsibility. Huh? Written constitution is a federal feature. No, that is unitary. Parliamentary system. I'm talking about. Collective responsibility and head of the state is PM. Real and nominal executive. And head of the state is president. Dissolution of Lok Sabha. Yeah, collective responsibility. And political homogeneity. What is political homogeneity? Political homogeneity. Does USA have political homogeneity? But does it have political homogeneity? What is political homogeneity? తెలియాలి కదా. Until unless you do not understand what political homogeneity is, you will not be able to understand or remember. Right? What is political homogeneity? Political homogeneity is nothing but despite many parties being present, they all have the same ideology. For example, if you see in USA, there is Republicans and there is Democrats. They have two different ideologies. That is not political homogeneity. Political homogeneity is both having same ideology. Even if Congress is there, even if BJP is there, both are having the same ideology, that is improving India. That is called what? Political homogeneity. Then you have double membership. What is double membership? That is real and nominal executive. Yeah, MP and minister. MP is also part of the legislature and also is part of the executive. That is nothing but dual membership, right? MP and minister. These are all the features of parliamentary system. One is what? Dual membership, collective responsibility, head is the PM, real and nominal executive, dissolution of LS, political homogeneity, and also secrecy. Secrecy is usually considered as part of parliamentary system. Head of the state is president. That is not actually part of parliamentary system. President, yeah. True. Yeah, my bad. Okay. Head of the state. government is PM, meaning that leadership is by PM. That is what is part of parliamentary system. Okay. So yeah, these are the two aspects that you need to remember: federal features and parliamentary system, because India is a federal and based on parliament, right? So now let us look at the options. What is it saying? Independence of judiciary. That is the federal feature. So answer is A. Then you have delimitation. It has happened 4 times. Yes. How many years? What are the years? 1952, 63, 72, 2002. 2002. Right? These are the 4 delimitation commissions that have happened. Indian state government have no power for making rules for grant of concession in respect to extraction of minor minerals, even though such minerals are located in territories. In India, central government has the power to notify minor minerals under the relevant law. What is right? Which one is right? One is right, one is wrong. Hmm? Second is wrong. First is right, second is wrong. Yeah. With reference to the union budget, what can you notify? Central government has the power to notify minor minerals under relevant law. Yeah, actually, this is very generic. If you actually see, the first statement is more specific. Second one is more generic. Right? It's saying India, state governments have no powers for making rules for grant of concession in respect to extraction of minor minerals, even though such minerals are located in their territories. So statement 1 is wrong. Statement 2 is right. Okay. So answer is C. With reference to union budget, consider the following statements. Union Minister, on behalf of the Prime Minister, lays the annual financial statement before both the houses of Parliament. Is it? You know that everything that is happening is based on President. Everything is happening on the President, not Prime Minister. Yeah. So it is President. First is wrong. At the union level, no demand for grant can be made except on the recommendation of the President. True. How many did we remove? Only one. Parliamentary committees. It was initially it was an ad hoc committee. Only a member of the Lok Sabha can make a complaint relating to the unethical conduct of a member of the Lok Sabha. This committee cannot take up any matter which is sub judice. I told you that if there is anything legal, it is most probably right. Sub judice is a legal word. What is sub judice? Yes, it has. The matter went to the court. If something went to the court, why would a parliamentary committee come and take it? So obviously second is right, because it is actually legal in nature. It was initially an ad hoc committee. It is a very plain statement. But if you look here, it's saying only a member of Lok Sabha can make a complaint relating to unethical conduct of a member of the Lok Sabha. If a member of Lok Sabha went outside and is talking bad about Raj Sabha, doesn't the person of Raj Sabha have the right to make complaint? Yes, obviously. So second statement is right. So 1 and 3 is wrong. How many did we remove? Are you noticing the pattern, right? You're only removing 1. As per the rules and procedures of the conduct of business in Lok Sabha, the elections of deputy speaker shall be fixed on the date as such, as fixed by speaker. For the elections of deputy speaker, it is the speaker who is fixing the date. For the election of speaker, who is fixing them? It is the president. President will fix for speaker, and speaker will fix for deputy speaker. And for resignation, who will write for whom? If speaker is resigning, he'll write to deputy speaker, and if deputy speaker is resigning, he'll listen to speaker. Okay. So yeah, it is saying as per the rules of procedure and conduct of business in the Lok Sabha, the election of deputy speaker shall be fixed on such a date as the speaker may fix. There is a mandatory provision that the election of a candidate as deputy speaker of Lok Sabha shall be either from principal opposition or a ruling party. It's not a mandatory, right? 2 is wrong. The deputy speaker has the same power as the speaker when presiding over the sitting of the house, and no appeal lies against his ruling. True. The well-established parliamentary practice regarding the appointment of deputy speaker is that the motion is moved by the speaker and duly seconded by the prime minister. Nothing is like that. We are removing 2 and 1. Answer is 1 and 3. Right? Sometimes there's no need for you to use any elimination techniques. With reference to the Speaker of the Lok Sabha, consider the following statements. While any resolution for the removal of Speaker of the Lok Sabha is under consideration, he shall not preside. True. Obviously, he's being removed. Why would he preside? Right? Secondly, he shall not have the right to speak. No. He shall not be entitled to vote on the resolution in the first instance. Again, no. At the time of removal, the speaker can vote at the first instance. Only when the speaker is presiding, they have to vote at the casting vote. So 2 is wrong, 3 is wrong, only 1 is right. He can vote, but not a casting vote. Okay. On the dissolution of the House of the People, the speaker shall not vacate his or her house until the immediately before the first meeting of the House of the People. I think, which article is it? I think it is Article 76, I guess. No. 70, what is 76? Attorney General, no? I think it's 60? 67. No, I don't think it's 67. Yeah, look at the articles. Sometimes remember the articles. Okay. According to the provision of the Constitution of India, a member of the House of the People, on being elected as a speaker, shall resign from his or her political party immediately. This is not part of India. This is actually part of British. This is part of British parliamentary system. But in India, they expect to be impartial. Right? If you are a member of any political party, while going to the chair of the speaker, what you'll do will be impartial. Treat both the parties similarly. So that is the only clause that is there for speaker. There's no clause that's saying that they have to resign from the political party. So 2 is wrong. 2 is wrong. The Speaker of the House of the People may be removed from his or her house by a resolution of the people, House of the People, passed by a majority of all the then members of the House, provided that no resolution shall be removed unless at least 14 days of notice has been given into the intention of the resolution. Deputy Speaker. When Deputy Speaker is absent, Deputy Speaker will be residing, and if the Speaker is dead or expired, then President will appoint. In this case, Deputy Speaker will be there. Okay. Yeah. Now, what kind of majority is this? Effective majority. What is effective majority? Majority present and voting. That is special majority, no? What is the difference between special majority and effective majority? Are you sure? Special majority and effective majority. Right? Let's say a house has 100 members. Right? The house total strength is 100 members. Right? And out of those, 5 members are vacant. 5 seats are vacant. 95 members is the strength of the house. And out of the 95, 80 members are present. 80 members are present. 70 members are voting. And 10 members are abstaining. This is the scenario. Okay. Now, simple majority is something where out of the 70, majority majority of the 70, meaning that what is majority of 70? 35 plus, meaning that if there is 35 plus 1, 36 votes, that is called simple majority. Okay. Special majority is where the total membership 50 greater than 50% of total membership. What is total membership? 100. Greater than 50 means 51. 51 is the votes that you need. Total membership greater than 50% of the total membership, and also 2/3 of present and voting. 2/3 of present and voting means 47 something. So the highest number that is required is 51. This is nothing but special majority. Now what is effective majority? As I told you that there are 100 members and 5 members are vacant. That is the effective strength. Removing the 5 members vacant from the total majority is nothing but effective strength. So 95. So greater than 50% of the 95 is nothing but effective strength. What is greater than 50% of 95? 40. That is called effective majority. Okay. For speaker, it is effective majority. For constitutional amendment bills or what do you call removal of president, removal of CAG, removal of Supreme Court judge, it is all special majority. Okay. Remember this. You might get a question because speaker is effective majority, CAG is special majority. Remember this because these kind of things UPSC might ask, as it has asked in economy. In economy, it started to ask solvable questions. It might ask these kind of questions in polity. You never know. So keep this in mind. Right? So yeah, answer is speaker shall not vacate immediately. Second is not there. A speaker of the house may be removed from his or her office by resolution of the people of the house with a 14 days notice. So second one is wrong. 1 and 3 are right. With reference to the Indian polity, consider the following statements. An ordinance can be amended by an act. I mean, it's saying that an ordinance under Article 123 and this for president. 213 is for governor. Okay. An ordinance can amend any central act. True. It's only talking for president, not for state. Okay. An ordinance can abridge fundamental right? No, obviously. What is it doing? Ordinance has the same effect as a law, but it does not have the same effect as a constitutional right. So 2 is wrong. An ordinance can come into effect from a back date, meaning that it is retrospective. Yes, it can come back retrospectively. How many are we removing? Till now, out of many questions that we discussed, only 1 or 2 questions where there are 2 or more options that have been removed. Otherwise, only 1 statement was removed and all the other statements are right. Use this in extreme scenarios only. For majority of the things, depend on your knowledge. Do not depend on these tricks. And just showing you a pattern. Okay. Consider the following statements with regarding to pardoning power. Exercise of this power by the president can be subjected to limited judicial review. The president can exercise this power without the advice of central government? No. Obviously, again, president is bound by the advice of central government. 2 is wrong. And the exercise of this power can be subjected to limited judicial review. It's not saying complete judicial review or absence of judicial review. It's saying limited. Obviously, limited is there. They cannot do arbitrary actions. Limited means sometimes when if Supreme Court thinks that this particular pardoning power is wrong, or if that particular action taken by the president is not right, that is when Supreme Court will jump in. That is why there is judicial review, limited. If there are 100 scenarios where president has pardoned, 70 scenarios it will let go, 30 scenarios it will take. That is limited. Okay. So yeah. Now when it comes to pardoning powers of president and governor, who has more? Governor. Governor can pardon, respect, remit, commit, right? Everything but nothing with related to death sentence. right? Nothing related to death sentence. But when it comes to president, president can do everything, including death sentence of state, right? Whenever there's a death sentence case in the state government, that can also be taken up by the president. And president can also act in the case of martial court, whereas governor cannot take case. Right? That is the difference between president and governor. Nothing much to think here. Okay. So answer is A1 only. I think this is the not the last paper. Okay. In India, there is no law restricting the candidates from contesting. Again, this is a very hard question at that time. Okay. India, there is no law restricting that candidates from contesting one Lok Sabha elections from 3 constituencies. In 1991 Lok Sabha elections, Sridevi Lal contested from 3 Lok Sabha constituencies. Contradictory statements, right? Meaning that out of these one is right. As per the existing rules, if a candidate contests in one Lok Sabha election from many constituencies, his or her party should bear the cost of by-elections to the constituencies vacated by him or her in the event of him or her winning all the constituencies. Very specific and very extreme. Why would a party pay money for winning all the constituencies? So obviously you'll remove 3. So you'll have only 1 and 2, right? And if you had to remove from both of these, which one would you remove? Why? But second statement is contradictory. Man, first is also contradicting second, no?
She contested.
Yes, you cannot prove. Sometimes when there are statements which you cannot prove, hard to prove statements. I cannot prove that in 1991 Lok Sabha elections there was a person called Sridevi Lal who contested from 3 Lok Sabha constituencies. How can I prove? I cannot go there now. I have to search in Google now. Until and unless I search, I'll not know. Why would UPSC give some statement which I have to search? UPSC will not give, no. But it will give you a hint saying that I am giving you an extreme statement, saying that there is no law. That is why you will eliminate 1 and you will not eliminate 2. But for this also, it is very hard. I'm not saying that it is an easy question. It is a very hard question because there's no way with that amount of pressure you would be able to think this. All right. So 2 is the option. 1 is wrong. Political parties. Remember I told you about the 4-box elimination trick? Only 2 correct, right? Only 2 is the answer. This is happening. Here the Socialist Party was brought in by Acharya Narayan Dev and Swatantra Party was brought in by Rajagopalachari. Right? So answer is 2 only. We have looked at almost 20 to 25 4-box questions, I guess. Right? In all of the 4-box questions, it was only 2. But it was not the same case with 3 boxes. But I would again tell you that this is not absolute. Just because I see in a pattern doesn't mean it is absolute. UPSC has been known to show you that elimination techniques will not work. Okay, use them in extreme cases.
1 to 3 marks is the alternative.
1 to 3?
4 is only 2, only 3 is 1, 2, 3, 4 applies.
అర్థం కాదు
1, 2, 1, 4 applies.
1, 2, 2, 3 అని ఇచ్చారు సపోజ్
అచ్చా
ఓన్లీ 2 ఓన్లీ 3 కాకుండా ఓన్లీ 1 and 2, 2 and 3, 3 and 4 అలా ఆప్షన్స్ ఇస్తారు.
అచ్చా చాలానా. Then you have to know a little. Maybe elimination technique might work at that time. అప్పుడు ఏదో ఒక ఎలిమినేషన్ టెక్నిక్ తీసుకురావాలి. Otherwise you have to be strong in history. This is a modern history question actually. This is not part of polity. It's a modern history question. You have to know that Acharya Narayan Dev came up with Socialist Party. That is one trick. And obviously C. Rajagopalachari came up with Swatantra Party. Okay. Preamble. What is the exact constitutional status of India on 26 January 1950? It was a sovereign democratic republic. Right? Now what are the aspects of preamble? Justice, equality, liberty, fraternity. right? These are the 4 aspects present in preamble. Justice includes political, social, and economic. Equally,
Equality of thought.
opportunity, and status. Thought, freedom, expression, faith, belief. Right? Thought, faith, freedom, expression, belief. Right? Fraternity, unity, and dignity of individual. These are all the 4 aspects that are present in preamble. Right? President election. If the election of the President of India is declared void, that is the reason I'm telling you. And why did I tell you to read these kind of topics in depth? Because UPSC is asking these kind of questions. When you saw the non-constitutional body questions, was it in depth? It is not in depth. It was on surface. But if you look at President question, what is it? It is actually in depth. If the election of the President of India is declared void by the Supreme Court, all the acts done by him or her in the performance of duties of his or her office or the President before the date of decision become invalid. Is it? No, they do not become invalid. Election for the post of President can be postponed on the grounds that some legislative assemblies have been dissolved and elections are yet to be taken place. No. When a bill is presented to the President of India, the Constitution prescribes the time limit within which he or she has to declare his or her assent. Again, no. There's no time limit for President at all. So, all 3 are wrong. D, none is the answer. Consider the following statements with respect to election of President. Members nominated to either house of the Parliament or legislative assemblies of the state are eligible for electoral college. What is the electoral college? Only elected members. Elected members only. Elected members of state legislature, Rajya Sabha, and Lok Sabha. When it comes to impeachment, it is only Lok Sabha and Rajya Sabha. That no legislative councils or no legislature. Okay. Higher the number of elected members of the assembly, higher the value of vote of each MLA of that state. What does that mean? What does that mean? What does that mean? How do you calculate the value? Value of MLA is calculated by population of state by number of MLAs into 1000. This is how you calculate the value. It's saying higher the number of elected members of assembly, higher the value of vote of each MLA. Right? This is the vote of each MLA. Now, if the population is 1 lakh and the number of MLAs are 10, is it high or low? How much is the answer? You removing? So 10. But if it is 100, how much is it? So is it increasing or decreasing? What is it saying? So obviously second is wrong. The value of vote of each MLA of Madhya Pradesh is greater than that of Kerala. For this, you had to know that there is this 1971 census in which Kerala's population is higher than MP's population. That is why the value of vote of each MLA in Madhya Pradesh is greater than that of Kerala. Right? So actually, sorry, third one is wrong.
But by electing the president, all votes are equally.
For that is MP. MP, see, how is the vote calculated? MPs and MLAs. Right? MP's vote is there and MLA's vote is there. Or how do we calculate the MP's vote? value of MLS vote by MPs is nothing but how you calculate. They are adding both. That is it. There's no difference. Okay, MLS vote is different and MP's vote is different. Okay, the value of vote of each MLA of Madhya Pradesh is greater than that of Kerala? No, because at that time Kerala's population is higher than MP's population. And the second statement is also wrong. The members of nominated first statement is also wrong. The value of vote of each MLA of Puducherry is higher than that of Arunachal Pradesh because ratio of total population to the total number of elective seats in Puducherry is greater compared to Arunachal Pradesh. This one is right. This is a very hard question because, as I told you, some questions might seem easy when you come out of the exam hall. Those questions are very hard when you are in the exam hall. So that is why many people come out of the exam hall and say, "I did not answer this question." Why? Because of the pressure. So try to maintain a composure. As long as you maintain your mind and keep your mind calm, everything will be all right. Because if you see here, what is happening? You're noticing a pattern. I told you everything is based on common sense only. Right? You have attended 3 of the classes. I told you everything is based on common sense. Nothing is there which is given out of syllabus and something that you don't know. Nothing is given. No, everything is given in from those areas which you know. So obviously, what is required? Calmness of mind is most required when you are writing the exam. Okay. So answer is only one. Attorney General. Attorney General is nothing but Article 76. Attorney General of India and Solicitor General of India are the officers that the government who are allowed to participate in the meetings of Parliament of India. Solicitor is there. Solicitor is not only Attorney General is. So one is wrong. According to the Constitution of India, Attorney General of India submits his resignation when the government of which appointed him resigns. Is it? What is it saying? It's saying that Attorney General resigns when Lok Sabha resigns.
No.
Attorney General stays for the pleasure of the President. Right? Who all are staying for the pleasure of President? Governor, Attorney General. All India Service. NHRC. Ministers. Is on? Yeah. Commissions. Commissions of SC, ST, and OBC. CAG. Right? All of these people stay to the pressure. Yeah. CAG is also staying to the pressure of President. Right? Yeah. Answer is D. Neither one or two. I think this is the last. No, this is not the last. Next. Okay. With reference to the writs issued by the courts of India, mandamus will not lie against a private organization unless it is entrusted with the public duty. Right? What is mandamus? What are the types of writs that we have? Mandamus, habeas corpus, provision, certiorari, quo warranto. These are all the writs that we have. Mandamus is saying demand, meaning that they are demanding to do the duty. Duty of what? The government. They are doing the duty of government. So whom should we pressure? Someone who is doing the government duty only. What are the options saying? Mandamus will not lie against a private company or organization unless it is entrusted with a public duty. So until and unless they are doing a public duty, they cannot issue a mandamus. One is right. Mandamus will not lie against a company even though it may be a government company. No, any government company will lie. Any public-minded person can be a petitioner to move to the court to obtain the quo warranto. What is quo warranto? What authority? They are holding the public office. So any person can go and check for legality of that office, right? Quo warranto. Now, what is habeas corpus?
Body present the
The body with you.
Can it be issued for private individuals? What about preventive detention?
On the name of private, they introduce to the executives.
Hmm.
Police example. If a
Yeah. What about preventive detention? Is habeas corpus applied to preventive detention? Why not?
they mention the grounds and it's not.
Yes, it is valid. It is mentioned by the court. As it is mentioned by the court, it is legal, meaning that it is not applicable for habeas corpus, right? So habeas corpus is not applied for preventive detention or any jailing done by the court. What is prohibition and what is certiorari? In what cases?
Lower court orders.
Can you give me a for instance for prohibition?
If not comes under the certain judiciary of the high court, it is transferred to
To
the
stop the case from
Stop the
the case which is running.
extra jurisdiction it is taking.
exactly. Whenever let's say there's a subordinate court, that subordinate court, let's say there is the civil court. Civil court is there, and civil court cannot judge criminal cases. If the civil court is giving a criminal jurisdiction, then it is called what? Exceeding its jurisdiction. That is when prohibition will come in place. When will certiorari come in place then?
Quash the verdict of the lower courts.
If it is actually given an illegal order, illegal proceeding has also already happened, then to quash it, certiorari will take place. That is all about all the writs. So here answer is 1 is right, 2 is wrong, 3 is right. See, a writ of prohibition is an order issued by the Supreme Court or High Courts to the lower court for prohibiting the continuation of proceeding in that case. Meaning that prohibition is before, certiorari is after, right? With reference to India, consider the following statements. There is only one citizenship and one domicile. Domicile means permanent residing in one place only. A citizen by birth only can become the head of the state. No, this is present for which country?
Yes.
USA. It's present for USA but not for India. A foreigner once granted the citizenship cannot be deprived under any circumstance. Obviously, they can do it anytime. Because what? If they are betraying India, what will happen? They can remove. So 3 is wrong, 2 is wrong, 1 is right. Did the trick work here? But I also told you it will only work when look at the options. Yeah, this is the last question, I guess. Arunachal Pradesh, the capital is named after a fort and the state has 2 national parks. What are the national parks in Arunachal Pradesh? Dihang is Assam. Dihang. Namdafa, okay. Namdafa. And Dihang, Assam. Mauling. Mauling in the other national park that is present in Arunachal Pradesh. See, that is the reason we need to remember or take hints from UPSC. UPSC is saying that look at the PYQs. I might ask you a question. What if you get a question from in this year's paper that Mauling is from Arunachal Pradesh? You'll not know. Yeah. So yeah, capital Arunachal Pradesh is named after a fort, and the state has 2 national parks, meaning Namdafa and Mauling. Nagaland is a state that came into existence on the basis of a constitutional amendment. What are the other states that came into existence on constitutional amendment? Sikkim. Which constitutional amendment? Sikkim. 61. 61 is about. Yeah, 61 is voter. 69 is Delhi. Sikkim is 36. What is Nagaland then? 13. 13, this is Nagaland. 22nd. Goa is 56th. Meghalaya is 22nd, right? Then you have 52nd, 55th and 53rd. 55th is Arunachal Pradesh. Arunachal Pradesh is 55th and 53rd is Manipur. Right? These are all the constitution amendments that came, and this is where states have been accommodated. So what do we observe from this? That all the states have not been brought through constitutional amendment. Only some states have been brought through constitutional amendment, and those are Nagaland, Sikkim, Meghalaya, Goa, Arunachal Pradesh, and Manipur. Tripura, initially a Part C, it became a centrally administered territory within the reorganization of states in 1956 and later attained the status of full-fledged state. True. In which year did Tripura get status? 1987. It's the year when Tripura got status. So all the three statements are right. Answer is C, all three.
Sir, from the formation of state, no constitutional amendment is required.
No. There's no need for you to actually add or need a constitutional amendment. But for these, there are certain clauses, certain protections. That is why they give constitutional amendment. That is why if you see 371A, 371B, all of these states are there. Sikkim is there, Meghalaya is there, Goa is there, Arunachal Pradesh is there, Manipur is there. All of these are there in special category status. From 371A to how many? 371H. All of these are there. All the states are there in. That is why they have been brought to constitutional amendments. They have been given some extra privilege. So in order to give that privilege, they had to do a constitutional amendment. Otherwise, to bring them, there's no constitutional amendment. Okay. So yeah, answer is all three. And that ends the discussion of polity. Right? Right? Do you guys have any questions? No?
Sir, in the Assam also has a constitutional amendment.
Yeah. Assam. Assam, I don't think so. Yeah, I think they added Assam through a constitutional amendment, obviously. But I don't remember the act. But check once. Okay. Check once. But these are also there. All of these are there through constitutional amendment acts. I don't think Assam was there.
Assam also was there in 371B.
317B is there.
Then why won't we add?
True. Good question. Maybe adding them as a state is the reason why it came into existence. Maybe that may be a reason. That is the only thing I can think of. Otherwise, I'll check once again and I'll let you know. Right? You'll be here, I'm here. That's my cabin there. And tomorrow you can come and you can ask me, I'll let you know. Okay? Right. Thank you guys. I hope you guys notice some pattern from polity, environment, geography. So if you're studying polity, environment, and geography, study in such a manner so that it will be easy for you guys. Okay? Thank you guys.